Yeah, so I'll give you a bit of background because maybe most people wouldn't know this. But there was a conference in Western Australia in 2009, I think it was, organised by the AIJA, the Australasian Institute for Judicial Administration. And I was one of the keynote speakers, I think, one of the speakers there, or plenary or keynote, I can't remember. Anyway, there was an open discussion. It was working with interpreters in Australia, in courts and tribunals. And there was a lot of open discussion, and it was obvious that there was no consistency throughout jurisdictions, states, etc., about policies, how to work with interpreters, etc., etc. So the AIJA gave me some funding after that to do a national survey of interpreters and of judicial officers and tribunal members. So I did that, and that resulted in the 2011 AIJA report, which is about policies and practices working with interpreters in courts and tribunals. And that had, I think, 16 recommendations at the end. So it's an interesting read. It's short because it gives you the perspectives of both sides. So on the one hand, you hear the judicial officer saying the interpreters are, I'm not very happy with them, the quality, etc., etc. Not all of them, but, you get that. And on the other hand, you get the interpreter's perception or perspective saying, well, we're not treated well enough, we need this, we need that. But so dissatisfaction from both sides. So anyway, so one of those, the last recommendation was to create a national protocol on how to work with interpreters, because we did a review and Sylvia Martinez was my research assistant for that. So she'll remember.
Hi, Sylvia.
She was a student first, and then she worked as a research assistant on that. And we did a review of the policies. So we looked for the policies on working with interpreters or people who didn't speak English, etc., etc. They were nice, good policies all over the place. But most of the time people didn't know where to find them, or, there was, again, no consistency. They were all over the place. Some in bench books, some in guidelines, some in policies. Anyway, so that recommendation was to create a national protocol on working with interpreters in courts and tribunals so that there would be one document where everybody would go to, and instead of having to, where's that, everyone will go to one, everyone will do the same things, and everything will be clear. So I presented this at conferences and so on, different parts of Australia, and the reaction I got mostly was that because in Australia we have a state-based legal system, it would be impossible to have a national protocol. So the different jurisdictions like the Northern Territory, based on these recommendations and on, what was in the report and other things, created their own protocols, and some put it in the bench books, etc., etc. So there were bits and pieces everywhere, but it still, wasn't a national protocol. And I thought, that's, that's not very good that they're saying it's impossible. Then in 2015, I get a letter from the chair of the newly created Judicial Council for Cultural Diversity, JCCD it was called.
JCCD.
And this, the now retired Supreme Court Justice, Wayne Martin from WA, was the chair. And he sent me a letter to me and to another retired judge from Darwin, Dean Mildren, to if we would like to do this national protocol as the recommendation as per the report. That the JCCD thought that this was a good opportunity for the two of us to write a national protocol where I would concentrate on the interpreting side of things and Dean Mildren will concentrate on the legal side of things. So I thought, wow, this is all the Christmases come at once. I didn't think that this was possible. They said it wasn't possible, and now I get invited to do this. I said, of course, this is great. And then in conversations, after we agreed to do it, in conversations with different people, it was decided that instead of doing a protocol, it would be a bigger document, including more people, not just the two of us. So a committee was created, which was this subcommittee of the JCCD, under the chair of, I was going to say chairmanship, but she's a woman, under as the chairpersonship of Justice Melissa Perry. So this was the subcommittee that worked on the writing of the National Recommended Standards. And so it had representation from the judiciary, tribunal members, other legal professionals, NATI, and interpreting, obviously. I was the AUSIT president then, so I wore two hats. Magdalena Rowan was there with me as well. So we had, a good group, and within that group, some really active members of that group, including Justice Francois Kunz, who has become, one of our champions for interpreters.
I know.
So
he speaks so well about it too.
Yeah, no, he's very good. So we've got and that created the recommended national standards. The first one was launched in 2017, and then we continued with more people coming on board from different areas, and more judges who again are the ones who are implementing everything and doing a wonderful job, and interpreters love them. They stand out. Judge Jane Culver is one who, from New South Wales, people always make good comments about. Now I can't remember her name, but another judge in Queensland. Anyway, so then a few things were updated. Materials were created, so materials for training of lawyers, of judicial officers. So on that website, now it's called the JCDI, so Judicial Council for Diversity and Inclusion now.